So, good day, ma'am. I am Arnold Pellegrino and I am here to discuss about the law on partnership and corporation. So, in this topic, we can differentiate the various kinds of partnership and corporation, and also we know the responsibilities of partners and incorporation. So, start. So, in Article 1767, partnership is a contract of two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. So also a partnership is an association of two or more persons to carry on as a co-owners of a business for profit. And also, a partnership contract is based on trust and confidence. Hence, the fiduciary relations in a partnership stems from the principle of delectus personae, wherein no one can become a partner in a partnership without the consent of all the partners. So, there are two essential requisites of a partnership. These are an agreement to contribute money, property, industry to a common fund. This is complied with if each one of the partners brings or obliged to bring something to the partnership, and that which is brought becomes common property. And the second is the intent to divide the profits among themselves. This is complied with if partnership is established to obtain profits. Profit must be common to all partnership, and profit or loss must be divided among the partners. So these are the advantages and disadvantages of partnership, of forming a partnership. So the advantages is it is easy to form and it improve growth possibilities, and the last advantage is the freedom from bureaucracy. And the disadvantages of forming a partnership is instability. There is a stable, then difficulty in obtaining large sums of capitals. The third is the firm is tied to the act and judgment of one partner as agent. And the last is difficulty in severing partnership ties. So there are classification of partnership. The first classification is according to subject matter. So under this, the universal partnership, a partnership where all of the partners contribute all of their properties to the common fund and speaks of a particular purpose or subject matter. The second is according to liability. So it says that general partnership is composed of a general partners where all liabilities extend to their personal properties. And second is the limited partnership. So usually attach the word LTD, limited, at the end of the company name. One formed by two or more persons having as a member one or more general partners and one more limited partners. And the last is the according to duration. So under this, the partnership for a fixed term. So it says that is one in which the term of its existence has been agreed upon expressly as when there is definite period, or impliedly as when a particular enterprise or transaction is undertaken. So the forms of partnership are a partnership can be in any form, even if not recorded at the Office of the Security and Exchange Commission, except when it is stipulated. Two is when immovable property or real rights are contributed, in which case there must be a public instrument to which is attached an inventory of immovable properties and signed by the parties. Otherwise, the partnership is void. In case of limited partnership, the parties must sign and swear to a certificate which shall state, among others, the name of the partnership, adding the word limited, and the character of the businesses. File file for records the certificate in the Office of the Securities and Exchange Commission. So there are three obligations of partnership. The first is the where contribution is money or property. Another is the preserve the property. Second is the deliver the fruits from the time of agreement. Third is the warrant against evictions and hidden effects. Fourth is the transfers ownership on delivery to the partners. The fifth is the pay damages for the delay without necessity of demand. And last is the bear the rest of loss before delivery. And the second obligation of partnership is where contribution is industry. An industrial partner, a partner who merely contributes industry or services to the common fund, cannot engage in business for himself unless the partners expressly permit him to do so. And the third is obligation of the capitalist partner. So a capitalist partner, a partner who contributes money and property to the common fund, is prohibited from engaging in a business in competition with the partnership unless there is stipulations to the contrary. Four is the responsibility between partnership and partner. The partnership shall be responsible to every partner for the amounts he may have disbursed in behalf of the partnership. For interest and damages from the time of conversion for any sum of money which he may be taken from the partnership coffers and converted to his own use. B is for damages suffered by the partnership through his fault. Third is for any benefit derived from him without the consent of the other partners from any transaction connected with the formations, conduct, or liquidations of the partnership, or from any use by him of its property. The fifth is the sharing of profit and loss among partners. In the absence of stipulation, the share in profit and loss shall be in proportion to their respective capital contribution, except the industrial partner who shall receive a share of the profits as may be just and equitable under the circumstances. Property rights of a partner. A partner cannot assign his right with respect to the specific partnership property for the partner's individual debts or for legal support. Liability of individual partnership to third person. So, all partners, including the industrial partner, are liable pro rata with all their properties for contracts with their persons provided. They were entered into a name for the account of the partnership under its signature by persons authorized to act for the partnership. The partners assessed are already exhausted. 8 is the liability of the limited partner. A limited partner is liable as a general when he allows his surname to appear in the partnership name and when he takes part in the control of the business. So, this is the law on corporation. So in Section 2, corporation defined as an artificial being created by operation of law, having the right of succession and powers, attributes, and properties expressly authorized by law or incident to its existence. So, in the Philippines, the law which governs the creations of private corporation is Batas Pambansa 68, known as the Corporation Code of the Philippines. So right of succession means that corporation has the capacity to exist regardless of a debt withdrawal, insolvency, or incapacity of the individual stockholders, and regardless of the transfer of interest or shares of stocks. So there are different kinds of corporation. The first is the stock corporation. So, one which has a capital stock divided into shares and is authorized to distribute to the holders of such shares, dividends, or allotments of the surplus profit on the basis of shares held. Also, the non-stock corporation, one where no part of its income is distributable as dividends to its member, trustees or officers subject to the provisions of the Code on Dissolution. Also, the corporation de jure, a corporation organized in accordance with the requirements of law. De facto corporation, a corporation where there exists a flaw in its incorporation. Public corporation, one formed or organized for the government of a portion of the state. It is created by its own charter of the exercise of a public function. Example is the barangay, city, municipality. Private corporation. So it's a private corporation. One form for some private purposes, aim or end. It is created by incorporation under the General Corporation Law. These include a government-owned and controlled corporation with an original charter and quasi-public corporation. A private corporation performing public functions. Corporation sole. Sole corporation, one organized for the purpose of administering and managing a trustee the affairs, property, and temporalities of any religious denominations, sect, or church. In this corporation, there is only one incorporator, a monastery corporation, one organized for a charitable purpose. Domestic corporation. So, a corporation formed, organized, and existing under the laws of the Philippines. So, foreign corporation. A corporation formed, organized, or existing under any laws other than those of the Philippines and whose laws allow Philippine citizens and corporations to do business in their own country or state. So these are the advantages and disadvantages of corporation or corporate organization. So the advantages is strong separate juridical personality, limited liability to investors, free transferability of units of ownership, centralized management through the board of directors, professionalism, and last is the easier to sell small amounts of stock to raise capital. So the disadvantages of a corporate organization is extensive government regulation, double taxation, activities are limited by the charter and various laws. Steps in creation and organization of corporation. First, the promotion. Second is incorporation. And last is the formal organization and commencement of the business operation. So the contents of the articles of incorporation. These are the content of the articles of incorporation. The name of the corporation, the specific purpose or purposes for which the corporation was incorporated, the place where the principal office of the corporation is located, the term for which the corporation is to exist, the names, nationalities, and residence of the incorporators, names, the nationality, and residence of the incorporating board of directors until the first regular directors or trustee are duly elected and qualified, the authorized capital stock, and the amount subscribed and paid by the stockholders or incorporator. So these are the articles of Article 1, subscription, issuance, and transfer of shares. So these are the following articles. And that's all. Thank you.